Hey, Aaron. The Aaron and Chuck show today. Jesse's off giving a talk. I assume on litigation to a bunch of lawyers, and Greg is, I don't know, on a bike. I don't know where Greg is. Maybe he'll be joining us shortly, and we'll let him in. But we wanted to go live today. Hey, Aaron, it's great to be back.
Welcome back. It's fantastic to see Chuck. I know we've been getting lots of well wishers from IMMPAct clients and everywhere else. So welcome back.
Well, I even got a delightful get well card from Jermara and Tim Sankey from our 601 litigation.
Oh, that's so
Clearly,
nice.
they're big Longhorn fans.
We won't hold that against them.
Thank you. Thank you. And all the well wishes and prayers and thoughts. It was kind of a crazy situation. My advice to you is don't get sepsis.
Yeah, Audrey had that, and it was bad.
Bad.
Yeah,
bad.
All I can say
is
that with Audrey's case, it was sort of like there was about a day or two that we were like really nervous about whether she was going to.
Well, if you Google it,
recover or not.
40% of people die from it.
Yeah, no,
that's serious.
It was very, very scary.
Or they lose limbs. All kinds of crazy stuff happens.
Yeah.
So I'm very, very blessed and very, very fortunate, and appreciate all my friends and colleagues that supported me through it. It's been like Mr. Toad's Wild Ride. The worst part, perhaps, because oddly enough, what caused this was a kidney stone, except it wasn't a case that had any pain. And I was talking to Aaron about this briefly about how does a kidney stone not cause pain? You may recall that on July 4th, I popped a disc in my back. An L2 and L3, which is the nerve.
That's the pain.
Which is the nerve that runs down your side over the front of in my case, my left leg.
Yeah.
Exactly where the kidney that was affected was. So it's just quite possible that I had my own epidural, courtesy of a popped disc in my back.
Yeah.
Which is why I never noticed it and why I never went to the doctor. And I figured it was a cold, I'm a guy. I'm an old white guy. It's like, suck it up. You'll be fine. You'll be fine. You won't die. So I'm back. And I was talking to Aaron just briefly. Apparently, I've missed nothing. Well, as I recall, right before this happened, the judge granted the stay in our 601 case. Is that right? Is that kind of where we are?
In that case, yeah.
And I think that was literally right when this happened. That's been 6 weeks ago. I do know that yesterday the government filed a notice of another case came out. So basically, what the notice was is there's another judge in Nebraska who has ruled the government's way, and Judge Gerard, and he just did it again. All right, so but oddly enough, this judge, if he was going to rule against us, I think he'd ruled against us.
Yeah, just so we're now up to 41 people who've had approvals.
Okay, that's great news.
So I'm just glancing again at the dates for all.
Have we had a lot of movement of files going around, or is that episode now over?
No, we haven't seen that.
That had to be related to scanning.
Yeah, no, we know that. I'm pretty sure that was the case. We did just have in October. So the cases have been like March. Oh no, that's not an approval. They're approving March cases right now, March 2020 cases, I should say, based on our what we're seeing on our approvals. Looks like March 5th.
Yeah, I'd also noticed that I went online to meet with the client yesterday. He asked me how long was my 601A going to take. So I went online, and apparently they no longer differentiate between service centers on their online form.
Yeah.
It's just,
with these, I think with our case, it's hard to tell, Chuck and Aaron, whether our cases are sort of their own subset and they're working them in order with that group, or ours are just reflective of what's happening across the whole spectrum. And it's probably the latter. but hard to say. But it may be that if you're not in the I mean, the benefits of our litigation right now, I think, are yet to be seen because we're waiting on the court to actually do something.
Now, in that case, we are. I think we're going to be part of an amicus briefing that's in the Ninth Circuit case. Am I not correct about that? So the Ninth Circuit's basically dealing with this issue on appeal out of Nevada on an expedited basis, correct? For the 601A?
That's right.
That's right. So I would imagine we should be doing an amicus brief on this.
Yeah. So that case is obviously critical to our case.
Yeah.
And once there's some movement on that case, then I think we're going to then we should see some pretty significant issues resolved.
My experience with the Ninth Circuit, I actually that's the first place I ever did oral argument was in the Ninth Circuit, many 34 years ago. They're not the District of DC, which sits on appeals apparently for over a year. They do adjudicate them pretty quickly. But the downside to the appeals, we don't know who the judges are. Unlike when you're at the district court level like we are, it's assigned to a judge. But really, until about a day or two before oral argument, you don't know who you're arguing to. Now, the Ninth Circuit has historically been the most, quote, liberal, pro-immigration circuit in the United States, but Trump appointed a lot of people to the Ninth Circuit. So we just don't know what our panel is going to look like for that particular case. But I know we're taking the things we're not doing now, and we're adding that to that case to try to bolster that case going forward. Because I don't know what their arguments were down below. I don't know what type of briefing they had. I do know in our case, it's world-class stuff that we've given the judge.
I also wouldn't. I'm not as concerned as others about who appointed a particular judge on some of the issues that we litigate. Where first of all, there's a lot of judges out there who are very conservative that mistrust government. And that's usually to our clients' benefits on there, where they have an opportunity to punish the government for things that they're doing that are hurting people. There are plenty of judges on both all ends of the political spectrum that are perfectly happy to do that. So, I know that a lot of times we'll look and see who we drew and try and use that as some kind of way to predict what's going to happen, but I'm a lot less nervous than I used to be about who gets the draw on there. If we feel like our case is just and we have the law behind us and we have a good set of facts and people in sympathetic situations, then I wouldn't worry as much about that. With that being said, there are actually some judges as well who are in the opposite, and it doesn't necessarily matter whether they're who appointed them, where they just are inclined to give the government as much latitude as they want. And those are the scarier judges, the ones that basically are not willing to have, to rein anybody in.
So we'll see. Now, my question is this: I mean, probably his case is stayed, so we don't have to do anything. But I would love to file something with the court that says, "Hey, by the way, they are now more opaque on processing times than they've ever been.
Yeah.
Now we don't know where any case is pending, however long it's taking." I mean, I just think it's ridiculous that USCIS has now decided to bring the curtain down even further on processing of these cases. And as I look through other types of cases, this is the only one I see like this, where it says all service centers.
Mm-hmm.
Chuck, last week while you were out, one of the things we talked about was on one of their stakeholder engagements recently, USCIS claimed that they think they'll have processing times down to 1 year by the end of this fiscal year. So by
And
1 year from now, there will be 1 year processing times on 601As. And we were just looking at the quarterly statistics about how many applications are coming in and how many are still pending. And it's almost impossible to think that they're going to be able to accomplish that.
Unless they are not being transparent and they're only talking about last in will have a 1 year target date and not all the people that have pending. I mean, I agree with you. I don't think that there's any way that they're going to work through that whole backlog and have the overall processing time down to 12 months.
So
yeah, I think you're right. I think that's what they mean Even that though sounds, well, I hope it's true.
Well, I didn't know this. They finally came out with Q3 numbers last week, right? So looking at this and the 601A waivers, just in the third quarter, they received 8,500 and they only adjudicated 4,200.
There's another way.
1,000 more cases behind in one quarter.
There's another way they could fudge the data too, and that is they could say, once, start the clock at the point when the hard service center got these cases, and then say we're working them in order, and that we'll start at the back, and all those cases that we're working will, they could try something like that and basically start the clock now and say it'll be a year from now. I still don't think they can do it.
Well,
there's a lot of ways they can play games with the numbers to claim that they have a 1-year processing time. Well,
perhaps what's more ridiculous, on their fiscal year to date numbers, they had received 25,000 of these cases and only adjudicated 7. So in the first half of the year, they only adjudicated 3,000 cases.
For newly filed. Or is that for everybody?
No, I mean, these are rolling numbers. So these aren't, they adjudicated 7 of the 25. They adjudicated 7 of the 138,000 that are pending.
Well, I mean, if I was sort of like somebody from USCIS, I was like trying to figure out how to explain that. Maybe their argument is that they've been, they put everything on a pause while they've been getting everything into everything scanned in and everything transferred to the Hart's jurisdiction, and that they can move things a lot faster now. And I think it is possible, once if everything's in the system now, and there's no more data entry, we do know that electronically filed applications can go pretty fast. We've seen that with the parole applications. We've seen that with employment authorization documents. We've seen that with naturalization.
But those are easy applications. These are very fact-intensive adjudications.
No, I get it. Although they should be able to move each case much more quickly than when it was all paper.
Clearly, they have a decision template, a decision tree they use as part of.
No, just give it to the algorithm and let the algorithm decide.
I think they're a long way. They're still using DOS 3.6, I believe, as their operating system at USCIS. I love statistics. I was a stat major before I realized I had to take calculus, and I said, no, I'll go to law school instead.
I love calculus.
I hate calculus, man. It looks like the only applications that they actually have gotten caught up, or in other words, they've adjudicated more than they received the fiscal year, was I-130s, marriage petitions, except there's still 2 million of them pending.
Yeah.
And yesterday I had a client come in, and he had sponsored his daughter in 2010. So a married daughter, so F3.
Yeah.
And go to the visa bulletin. It's current for filing, unadjudicated, 13 years, And so I spent a little time yesterday in between all the other things I was doing, and I found something interesting. Do you know how long an I-130 takes if it's at the National Benefits Center? You don't. I know you don't, because 55 months.
Oh yeah.
Oh my God.
For a spouse of a U.S. citizen.
Right.
For a spouse. But in California, it takes 15 months.
Right.
So, I mean,
anyway,
it's just
it's sort of like, but this ties into some bigger things that are going on at the agency as far as what they can do. I mean, the big thing that, Chuck, while you were gone, that happened was the announcement of TPS for Venezuela. And the belief is that there's about 500,000 people that might fit into that. And that means 500,000 TPS applications, I guess that's the 821, and then 500,000 employment authorization document, each 765 applications. All of that is presumably going to be e-filed. And I think you're wrong when you say that they don't have the capability of letting algorithms do a lot of the work on these cases. I think they actually could basically have a setup where these cases are approved and then flagged for further review if there's any factor, if there's any red flags that come
You
up.
have far more faith in the United States citizenship.
Well, I know. Look, I have some reasons to believe that that's something that they can do. But with that being said, the goal, I think, one of the remedies that's available in the 601A case, and Jesse's talked about this before, is providing some kind of interim work authorization for people with the with 601A pending applications, or at least after a period of time, and having an e-filing, and they have a pretty robust 765 e-filing system right now. And we also know the agency, from that 2015 memo that got leaked to me, they know they have the authority for almost any reason to adjudicate, to give somebody, to approve a 765 for almost anything that they want, for anybody. They have very, very broad authority to issue work cards at the agency. And they could craft some kind of remedy for our plaintiffs, and then for the entire group of 601A applicants on there. And part of that is the reason why it would work. Remains to be seen if it was, but one of the reasons it could work is because of everything that they're doing as far as switching to this electronic filing system for the TPS applicants. So they are connected, even though it's very worrisome from our plaintiff's point of view that all of a sudden they have 1 million new applications that are about to be fed into the system from the 765s and the 821 applications for that 500,000 population. But it could be potentially good news if they are able to use that system for 765s much more broadly and getting it out of the hands of human beings. And the 765, there's really nothing that there's nothing a human being needs to do on a 765 case on there.
It's interesting.
All they're looking is to see whether the person has an application that's pending that makes them eligible for it, or whatever the criteria are that makes them eligible for it. But a human being is not going to help in that. So either they can turn it over to an algorithm, or they could give somebody the ability to work just based on a receipt and call that an employment authorization document, and worry about later on about producing the actual physical card. But there's not a lot of risk.
I will tell you, if you look at the total of the 765s they received year to date, that's about 2.2 million EAD applications they've received year to date. They've denied about 7% of those, which is maybe 10%. They've denied about 300,000 of them.
Yeah, I'm guessing it's because for things like they checked the wrong box. They're almost all paper ones, I bet.
I would bet. But that's what's interesting is that grouping, that 2.2 million, is triple any other application they got. So it's probably, I would guess, look at just it's probably 10% of their overall workload.
Yeah.
That can be automated, but they didn't put us in charge.
Well, they could do that also with the parole documents.
Yeah.
On there, which I was James Hollis in our firm was ranting about this yesterday on Twitter about an expedite he's trying to get on that, and it sort of raises this bigger question: is like, why are they spending the resources that they spend to adjudicate advanced parole documents? What are they? That one also, Chuck. I'd be really surprised if there's more than 3 or 4% denial rate for advanced parole.
What's odd?
What's that? They don't put that.
It's not on here.
Yeah, but that's the biggest waste of time I think going on at the agency on there. Is like you can presume that somebody that just spent all that money to file an adjustment application is not going to abandon it because they're taking a plane trip out of the country. I don't know what the connection is, why they think somebody traveling outside the U.S. Would be, that's a signal that they've abandoned their adjustment application. Yeah. So they need to
$575, baby.
Well, that's another one where they could basically just incorporate that travel authorization into the I-485 receipt. I understand the money part of it, but it basically is, if you're collecting the money, and it completely paralyzes the agency. But maybe you're right. They are in this dependency.
Well, if they have 2 million EADs, they likely have at least 500,000 advanced paroles.
Yeah.
In a year. And if 500,000 times 500, that's $250 million. That they're not going to walk away from that. They're not.
No, but
$250 million.
They could just basically raise the fees on the adjustment application and do away with those documents and just incorporate that into the receipt for the receipt for the 485. Save themselves all the work.
By the way, I did inquire.
Get all the money, and basically make everybody happy at the same time.
I did inquire yesterday on a call I was on when they're going to issue their fee increase. Because I thought it would be this fall. I mean, no, it's this spring maybe.
They can't even raise money.
They can't even do a resolution to raise their fees.
I mean, that's the one thing that it's like. I have some sympathy for them if that's really the source of all their problems. And for goodness sake, get that rule out on there and let if that's going to solve all your problems on there. But they can solve a lot more of their problems by ditching processes that they don't need, raising the prices, and using that money instead. Use that money instead for things where they can deliver.
Hey, I want to switch over to the 601 application. Yesterday, the government filed this other judge in the district, he ruled in the same way he ruled before. Aaron, you're I'm sure aware of the Afghan asylum class action that the judge in DC just ordered USCIS to adjudicate every Afghan case by October 23rd. That is I mean, the thing for us, they're like, hey, it's it's discretionary. There's nothing more discretionary than an asylum case. Mm-hmm. Perhaps we need to be submitting our authority. Hey, judge, by the way, this court in DC just did this.
There is something, by the way, that you raised that and I don't know if this could be done administratively or not, but you might have heard of something called the Lautenberg Amendment.
Yeah, of course.
Right. So the Lautenberg Amendment for those is something that Congress passes from time to time for Senator Lautenberg, who's passed away, where essentially for certain types of asylum or refugees, it flips the presumption. So instead of saying that your burden's on you, applicant, to show that you're a Baptist from the former Soviet Union on there, and that causing you persecution, instead it says, we're going to presume that if you're in that group, you're being persecuted. So really all you need to do is demonstrate that you are a member of that particular group, and you don't have to get into all the rest of it. I wondered, Chuck and Aaron, if that's something that, could be done without legislation, where the government could essentially say, we're going to have certain factors in your case that if you can demonstrate that you're a member of a particular group, we are going to presume, based on our own research and intelligence, that you have a credible case, and unless an examiner has reason to believe that either you're being fraudulent and you're not really a member of that group, or something about your situation would flip that presumption back. I wonder if that's one way that they could address that issue and potentially use that same logic in a bunch of other categories.
Well, I think that's a good point. And if you look at the USCIS policy manual on extreme hardship, they kind of do that. So they set out what they call our particularly significant factors, and they say that I don't know if it's in many cases or ordinarily, whatever the language is, that the presence of these factors will lead to a finding of extreme hardship. So it's supposed to set up this presumption that makes these quicker to adjudicate. And maybe it works. I don't know, but I think that's kind of the same idea of if you're in this box, if your case is in this box,
right,
and the presumption is it should be approved.
Right. If you're a female from Afghanistan, which would clear out half of the applications, you're in that, you've checked that box, and unless we have some reason to believe that they have some independent evidence that you were cooperating, you're a friend of the Taliban or something like that, that you're not going to have that issue. So okay, so historically they've done that, it sounds like. So maybe Chuck, maybe that's the way that they are able to do that, and maybe that's something we can think about as well. That in our application, as far as how they adjudicate the 601A cases and some of the other ones that we're working on, at least some way to think about it when they actually are ready to talk to us.
I went in and looked at the Ahmed case. Actually, I know it's DC. This is actually a Northern District of California case.
Yeah.
The Afghan case. And they clearly settled this case because they knew they were going to lose. So we don't have an order, but they settled a case. I mean, I wonder if we can argue this. They settled a case where they had argued that there was no jurisdiction for the court to handle the case.
Yeah.
And they settled it.
Yeah.
That's got to be an admission against interest in some way.
Yeah.
Well, I wonder if we can use this somehow.
We can use that in Shumalino for, as far as,
I mean, this
as far as admitting the conduct. So
I thought it was an order from the court after a decision, but it's a settlement agreement. But the briefings are really interesting, and government clearly took the position that they weren't. There was no authority of the court to adjudicate the case. It's the same thing they've been arguing all over the country, and here they caved. And I wonder if maybe in the 601 case we can say, "Hey, Judge Joseph, why the government's caved on this issue in other cases? For example, see Ahmed."
I like it.
It's interesting.
I mean, interesting. Let's talk about that offline. So, one thing that didn't happen in the EB-5 case is, which we settled, of course, favorably to our clients, and we've had a couple of our clients already approved according to that settlement, as they were promised to by the government, is I was going to send out the notice to the clients the Monday after I got sick, so I didn't get the notice out. So, Greg, I will get you an email, hopefully by Friday, to send out to our EB-5 clients about the settlement. So that's kind of out there. And what else is there, gentlemen? Is there? We've got the Ukrainian fee case, which is also stayed. I was a little curious to me what's going on in that case.
Not much.
There's some weird thing. Oh, there's some stay going on because of the motion. I'm confused by what's going on there.
So it is stayed. There's an automatic stay by statute that kicks in. And the end of the stay happens 60 days after the judge rules on the motion to transfer. It's actually a motion to dismiss and a motion to transfer, but we're waiting on the judge to rule on that, which is briefed. And then after the ruling, whether he denies the motion or approves it, the stay stays in effect for 60 days after. During which time, assuming for a second that they rule for us that it shouldn't be dismissed or transferred, they actually get a direct appeal of that to the Court of Federal Claims. So, and maybe it'll be stayed during that time too. So it's in a holding pattern while we wait for this.
It's nothing like rules written to favor the government. Isn't that just the way it is? Greg, I do want to talk about the H-1B lottery for 2024. Or is it 2025? When's the next lottery coming up in March? I guess it's for 20.
It will be for the 2024
fiscal year 2024 now,
25
right?
fiscal year, because the next lottery will be for October 1, 2024.
For fiscal year 2025, right?
Yeah.
All right. So I changed it. And the government has noted that they are in rulemaking.
Well, they are pretty far. Yeah, I do have some intel on that rule is coming really quickly, and the goal is they want that to apply to the next lottery on there. So, we don't know what's in it, but
we can suspect they're raising the fee from $10 to more.
Yeah, I think that's going to happen, but I also do expect that some of they've been presented with a million ideas for things that they can do to help reduce this problem that we litigated over, but we don't have any language yet. And that's, but I think we're going to see that soon.
Yeah, I heard that this fall, like in the next 30 to 60 days, we will be seeing some proposed regulation of some kind. So,
well, I think that's good. I mean, they should have done.
Me too. I mean, it's
they should have done that a while ago. Hopefully, they're taking some of the comments from the the universe of people that have been trying to fix this issue, either litigation wise or advocacy wise. But we will see. There's also something on a very similar track for adjustments applications. There's a rule coming for that. So, some of the stuff is sort of, you can tell, you can't tell a lot of it from the descriptions they give.
The notice is just vague.
But they did say in there that they were concurrent filing for religious workers.
Oh yeah, well they have to do that. They're getting pressure from every religious organization in America at this
That's
point.
in there, but there are several things that there's discussion of, and we could see some potentially significant movement on employment but the ability to file adjustment applications without necessarily having the whole allotment of visa numbers available. Basically, the Cyrus theory.
Yep. Hey, I wanted to mention something on EB3s. I wasn't just watching telenovelas and eating bonbons while I was out. I did actually check email.
Bonbons are off your diet.
Yeah, bonbons are definitely off my diet. Yeah. No more Advil, no more Coke. You see, I'm drinking a G0 today. Yeah, it's all that stuff's gone. But I had written a blog back in June about the coming apocalypse for EB3s.
Yeah.
And sure enough, I was right. I mean, because it's just math, right? And so I've got an article I'm finalizing for our friend Dan Kowalski on this issue. But EB3s are going to be, and I'm talking about EB3 worldwide, okay, are going to get really bad very, very fast. Why? Because everybody with TPS can do an EB3. All of them. All these Venezuelans and Syrians and people from every other country are finally realizing, I've got TPS. You mean all I have to do is get TPS, get advanced parole for any reason whatsoever, travel, come back in, and I can adjust status through employment? Yeah, you can do that. Well, that's gonna actually inundate the EB3 category worldwide, which is probably good news for everybody waiting in the backlog, because that's the kind of pain that Congress may in fact listen to, instead of from one country or two countries. When every employer is saying, I can't hire anybody for the next 10 years.
Yeah.
So this is I predicted it. I knew this was coming several years ago. You could see it demographically happening. And so that's kind of, I just want to preview that it's mucho malo.
We might be in this weird period though, Chuck, where Congress could actually do something on this issue.
Well, wait a second. I was going to ask you, Greg, after yesterday's debacle.
That's what I'm talking about on there.
Maybe
so
this is what
everybody's sort of like seeing in the news, that we are a country without a Speaker of the House, and that will probably be for a while, because I just do not see the Republicans being able to get anybody elected with their caucus alone.
I think Steve Scalise may get it.
I don't think so on there, because because at the end of the day, the same issues that were plaguing McCarthy will plague Scalise as far as what he has to give up to do that. But let's just say that this position, if and you might be right, and if he can get elected, we'll have 9 more months of basically the same business. But if he can't, and they can't find anybody that's electable over there, they're in a quandary as far as how they're going to move forward. And there is a broad agreement. The Republicans want to do an immigration bill. The Democrats want to do an immigration bill. They just want bills that are very different as far as what they accomplish. The Republicans want an enforcement bill. The Democrats want to do DREAM Act and all these other things. But there could be potentially to trade votes, and to one, to keep the government operating, 2, to keep the Ukraine money flowing, and 3, to do something on immigration that will be acceptable to both sides. They might have to craft something where they will, where they'll have some kind of compromise. And I don't know how, but without a speaker, basically preventing it from happening. Who knows? So there's just a lot of unknowns. We're in uncharted territory as far as how the House will operate without.
Well, I will tell you that interim Speaker McHenry is virulently anti-immigrant.
Right.
So
I get that. But he
He
also
hangs around. Don't expect anything. But he has no authority to do anything.
No, I understand that. It would have to be some kind of deal that was made, and but to the extent that the Republicans capitulate and know that they have to get the Democrats on board for whatever they need to happen. If they come to that conclusion, then the question is what the Democrats extract.
I will tell you, Minority Whip Clyburn was talking this morning on a morning show that he really liked Tom Cole out of Oklahoma, who, by the way, is not bad on immigration.
Yeah, I mean,
and along with a couple other names.
Yeah, there's the Omaha guy, Bacon, and there's a couple of and then New Yorkers that are the ones that are probably going to lose their seats. The next
they're peeing their pants right
now. There are probably 6 to 10 Republicans that the Democrats could potentially say are acceptable, that are perfectly fine doing deals with Democrats. And if that happens, you could see somebody get elected with 75% or so of the House votes with all the Democrats and then the normal Republicans on there. But the question is, what's extracted in exchange for making that kind of a deal? And the Democrats have a pretty strong, hand to play.
Well, literally, if McCarthy, historically, when a speaker has stepped down, they're gone. They quit. They're done, right?
Yeah.
If McCarthy leaves, they only have 2 over the number at that, 2 or 3 over the number at that point, because the Utah legislator quit, so I just do not see them functioning. And then, of course, there's a raft of articles today in all the political press about what a nightmare the GOP is. But my favorite thing, and what may have cost McCarthy his speakership, honestly, is right after the Democrats voted to save America and not put us in a shutdown, he blamed the Democrats for the potential shutdown.
Yeah.
If he had not done that,
he's not a very good politician.
No, he's not. He's just not. He's not building rockets to Mars. So, all right, gentlemen, it's great to see you. It's great to be back. I can't wait to see Jesse again next week. I feel good. I do have surgery tomorrow, but I'm sure I'll be fine.
All right. Good luck.
All right, guys. Take care.
We'll talk to you next time. Bye-bye.